Good afternoon, everyone. Good afternoon, everyone. Good afternoon, everyone. My name is Tony Singla, and it gives me great pleasure to welcome you all today to this year's commercial conference hosted by Birt Court. First of all, well done for getting here, given the train strikes and tube strikes, and it's the first day of the Cricket World Cup. We've decided to focus on class actions today because they've become prevalent, and they've become prevalent across all areas of law, and it seems we may have reached something of a tipping point. Now, as I'm sure everyone knows, class actions are a relatively recent phenomenon in this jurisdiction. Although for many years we've had the procedural tools to enable group litigation to be pursued, historically the number of group actions, whether through GLOs or representative actions, or even brought on an informal basis, has been fairly modest. But in the last 10 years or so, class actions have really taken off in this jurisdiction, so much so that they now form a major part of many of our practices. And there are various reasons for this rapid growth. Most obviously, the appearance of litigation funders in the UK market. There's obviously an unresolved question about how funders are likely to respond to the Supreme Court's judgment in PACAR, but the early signs seem to be that funders will not be deterred. Secondly, we've had the Supreme Court's judgment in Lloyd and Google, and despite the results on the facts of that case, the judgment of Lord Leggett has been interpreted, at least in some quarters, as endorsing a permissive approach to the commencement of representative actions, with Lord Leggett, for example, referring to the potential scope for bifurcated claims, with common issues tried first and then individual issues tried at a second stage. Thirdly, since 2015, as I'm sure everyone knows, we've had the new statutory regime for collective proceedings in the competition field, and that regime has already given rise to a huge wave of litigation, including the Supreme Court appeal in Merrick's and MasterCard. And the opt-out aspect of the competition regime is something which is new to this jurisdiction. So really what we've seen in recent years is a noticeable change of attitude on the part of the English courts, whereas previously they might have looked upon class actions with scepticism, something perhaps more familiar with our US friends. They've become increasingly more receptive, English judges, to representative claimants seeking access to justice on behalf of consumers with small claims that might not be economically viable for individuals to bring on their own. Now, the barristers at Birt Court have been at the forefront at the development of class actions in this jurisdiction. Many of us have acted and continue to act in a number of the leading cases. So we should have a very interesting afternoon ahead of us. You'll be hearing talks from a stellar lineup of silks and juniors, and this being the Chamber's annual commercial conference, the talks will focus on commercial law aspects of class actions rather than the competition regime. As you'll see from the programme, what we've decided to do is divide the conference into two parts. In the first session, we'll hear about different sorts of commercial class actions in terms of subject matter. So we first have a talk on securities litigation, and then talks on data and tech and ESG litigation. Those are areas which have already given rise to a number of interesting cases, but as we will hear this afternoon, there remain plenty of unanswered questions which will fall to be litigated in the future. And then after the tea break, we will hear more about the nuts and bolts of litigating class actions with some important practical insights on key issues such as GLOs and representative actions, especially post Lloyd and Google, funding and costs issues, so we'll hear about the ingenious litigation and the PACAR judgment in more detail, and jurisdiction, and we're fortunate enough to have two members of Chambers involved in the Brazilian dam case who we'll hear from later. So the plan is that we'll hear from two speakers on each topic, and then if anyone has any questions, we've left some time at the end of each slot rather than saving all of the questions until the end. So without anything further from me, I'd like to introduce our first speakers on securities litigation, Kyle Lawson on my right and Jacob Rabinowitz on my left, each of whom are involved in a number of securities cases. Kyle is going to talk about securities class actions, whether they can be brought as a representative action, whether Section 90 claims can be brought by aftermarket purchasers of securities, and also the reliance requirement in Section 90 and 90A of FSMA. And then Jacob is going to pick up various issues in relation to quantification of loss. For example, how is loss to be quantified and when is loss suffered in securities claims? So I'll hand over to Kyle.
Thanks, Tony. So good afternoon, everyone. As I'm sure you'll all be aware, securities class actions have been a major feature of the US legal landscape for a long time now. And on average, you get about 300 class actions issued in the US every year. And it's estimated that in the last 30 years, over $100 billion has been paid out in US settlements. Now, in contrast, until quite recently, such actions were almost unheard of in this jurisdiction. But that is definitely changing. And therefore, it's a particularly good time for us to talk about securities class actions. The framework in England for that kind of claim is not actually a new development. We've had a form of statutory liability for negligent misstatements in prospectuses for over 100 years. And the current versions of that legislation are now set out in sections 90 and 90A of FSMA, or Financial Services and Markets Act 2000. I'm sure lots of people are familiar with those provisions, but just in very brief summary, Section 90 provides a statutory cause of action for investors who acquire shares and suffer loss as a result of untrue or misleading statements or omissions in a prospectus. And in contrast, Section 90A is available to those who acquire, continue to hold, or dispose of shares in reliance on untrue or misleading statements or omissions in other kinds of published information. So, for example, annual reports, profit statements, and other kinds of market updates. And although there are obvious similarities between those two provisions, there are also a number of important differences. So, Section 90A applies to a wider set of information, but it also has a narrower scope. So, for example, it can only be used for claims against the issuer of securities. You can't use it to claim against directors. And claimants under Section 90A also have the burden of proving that misstatements and omissions were made dishonestly by persons discharging management responsibility within the company, which are often referred to as PDMRs. But in addition to Section 90 and Section 90A, investors also have the usual panoply of common law claims, so negligent misstatement, fraud, deceit, and a variety of equitable duties of disclosure. In the last 10 years, there have been a number of high-profile securities actions in England which rely on these cause of actions, and we've given a number of examples there. But we still have relatively few reported judgments. There have been a number of interlocutory decisions which are of some interest, but only 2 cases that have made it to trial. The first of those is Lloyd's HBOS, in which I appeared together with Helen Davies QC and Tony Singla, as they then were, and the autonomy litigation. But both of those were, in many ways, quite exceptional cases. And that means that we have a lot of unresolved questions which are still out there. We thought we'd pick up a few of those today, as Tony has identified. The first topic I wanted to look at is whether you can bring a securities class action as a representative action in England. And you're going to be hearing from Gerard and Jaamae later on about how that procedure works in more detail. But essentially, it lets a single claimant bring a claim in a representative capacity on behalf of a wider set of claimants, all of whom have the same interest in the claim. Now, the traditional view in England was that you couldn't use that procedure to bring a securities class action. Essentially, that was because it was difficult to say that any individual investor had the same interest as lots of other shareholders in the company. So particularly where you've got a claim for damages, and you've got issues like causation and quantum, those normally need to be assessed on a claimant-by-claimant basis, and you can't bring them as a class representative. So unlike the position in the US, securities litigation in this country is often thought to be opt-in rather than opt-out. Or in other words, solicitors and funders need to book build by identifying a large group of claimants and persuading each of them to opt into the claim against an issuer of securities. The problem with that is it's often a difficult, time-consuming and expensive process, and it's often cited as one of the main impediments to class actions in this country. But increasingly, however, there are signs that that is changing, and that claimants are trying to break the traditional mold of securities litigation in England. So in particular, claimants have been encouraged by the Supreme Court decision in Lloyd and Google, which seems to have endorsed a slightly more liberal approach to CPR 9.8 and representative actions. And as a result, one of the big trends we are seeing is class actions and claimants trying to bring claims with one claimant as a representative of other shareholders. So if that is permissible, it would be a somewhat curious result. It would mean that, contrary to popular belief, the procedural mechanism for US-style opt-out class actions has actually been part of English law for hundreds of years. It would mean that legislative reform of the kind that's been undertaken in the competition context would be unnecessary. So there'd be no need for opt-out collective proceedings orders, or CPOs, which have been introduced by the Consumer Rights Act 2015. So against that background, it's possibly not surprising that a number of defendants have already issued applications to strike out these claims, the first of which is due to be heard next month. Now, in light of that, it's difficult to say more at this stage about the merits of those claims, but you should definitely be watching this space closely for future developments in this area. The second topic I wanted to highlight is quite a short one, which concerns Section 90 of FSMA. Now, that provides a remedy to any person who acquired securities to which a prospectus applied. And there's a debate in the authorities about whether that applies to investors who acquired their securities as part of sort of general aftermarket trading, or just the first investor who subscribed as part of the initial offerings of securities. Now, on that, we currently have a position where there's conflicting obiter dicta. You've got a decision called Postfund and Diamond from the 90s, which is Mr. Justice Lightman, looking at similarly worded provisions of earlier legislation. He held they didn't apply to aftermarket purchasers. And then more recently, in a case called Hall and Cable and Wireless, Mr. Justice Tier was willing to assume that Section 90 allowed aftermarket purchasers to bring claims, although there's very little debate and discussion of the point. So that point will need to be resolved in a future case as well. It is important to note, though, that even if it's determined that Section 90 is available to aftermarket purchasers, those claimants are likely to face additional challenges when trying to bring their claims. And in particular, there's going to be a problem with proving causation. Because if there is a long gap in time between the prospectus being issued and then subsequent market trading, it gives a greater opportunity for other factors to influence the share price, as well as the misstatements and omissions about which a claimant might complain. So finally, the third topic, as part of a very sort of high-level summary of some of these key issues that I wanted to look at, is reliance. Somewhat surprisingly, Section 90 of FSMA does not expressly require a claimant to establish that it relied on any of the misstatements or omissions about which it complains. So on its face, that cause of action is available to claimants who never even received or opened a prospectus, and to those who never even read the specific misstatement on page 227, about which they later vociferously complain. So there is a debate in the in the textbook certainly, about whether a reliance requirement is nevertheless implicit in Section 90, and that will have to be resolved. There is, in contrast, no uncertainty about Section 90A. That provision expressly states that it's only available to investors who acquired, continue to hold, or dispose of securities in reliance on published information. Now, on that, you do actually have some recent guidance in the form of the first liability judgment of Mr. Justice Hilliard in the autonomy litigation, which looks and breaks down the requirement of reliance and what that actually contains. I'm not going to go through that in detail with you, but if so interested, you can find it at paragraphs 480 and following of his rather lengthy judgment. In other jurisdictions, though, particularly where securities class actions have a longer history, such as the US and Australia, claimants have developed increasingly inventive ways of trying to satisfy this reliance requirement. And what's particularly well known is the widely publicized fraud on the market theory in the US. So the argument here is that in an efficient market, the price of shares at any given time reflects all of the publicly available information about the company which is known to the market. So that will include any misstatements which have been contained in prospectuses and market statements and so on. So if an investor then purchases shares in reliance on that market price being the true and correct price, it's said that they're also relying indirectly on any misstatements which have informed the price. Anyway, that's the nice theory. There are reasons, however, to doubt that you can just transpose that American theory straight into English law. I mean, first of which, that's been developed in the US, which is not itself a criticism. But the US securities class action regime does have a number of both procedural and substantive differences to the regime in this country, and therefore there are reasons to think that that theory will not translate across the Atlantic, perhaps as easily as some other components. The last point I just wanted to highlight is actually about Lloyd's HBOS itself, which is quite a nice case study of just proving why, or showing why reliance is such an important requirement of these causes of action, and actually how difficult it will be to establish. That case was somewhat unusual because it concerned a shareholder circular, so not a prospectus. And as a result, you didn't have Section 90 and Section 90A claims. But the claimants did bring various claims for negligent misstatement and other things. And it's obviously well established that reliance is a key component of that cause of action. Now, on the fact, that proved to be an insurmountable obstacle for the claimants. There were eventually about 5,800 claimants on the GLO register. 4,600 of those, so about 80%, admitted at an early stage that they hadn't even read the shareholder circular that was an issue. So that's automatically fatal to all of their claims. Of the remaining 1,200, only 18 served witness statements at trial, and of those, only 4 actually claimed to have relied on any of the misstatements or said that they would have voted differently if something else had happened. And their evidence was rejected in any event. So, as you can see, any claims based on misrepresentation, if reliance is a component of that cause of action, are going to be very challenging when you're dealing with group claims with a very large number of shareholders or claimants. So that's a very sort of whistle-stop tour of some of the hot topics in securities litigation and issues which are ripe for determination in future cases. But even if claimants can overcome some of these hurdles and establish that they're entitled to bring claims, or that they have a cause of action which works and can satisfy all the components, they obviously still need to quantify their claims and establish that they've suffered some loss, which is an issue that Jacobs is going to pick up just now.
Thanks very much, Carl. So yeah, in the next 10 minutes, I'm going to look at 2 categories of issue in relation to quantum. The first being, as a matter of principle, what kind of losses are likely to be recoverable in claims under Section 90 and Section 90A. And then second, more briefly, as a matter of practice, the means by which the parties in the court might go about addressing issues of quantum. So just in that first category, issues of principle, I'd like to address 2 kind of sub-issues in particular. The first is a high-level issue, whether the fraud measure of damages applies in Section 90 or Section 90A. And the second is a much more granular conundrum that applies in relation to one specific limb of the statutory regime, and it's one that Carl mentioned. And this is whether loss can be suffered in a claim under Section 90A, in which it is alleged that a claimant continued to hold shares in reliance on published information. So just turning to the first of those sub-issues on the fraud measure of damages, many of you will be aware that in a common law claim in deceit, a claimant is entitled to that measure of damages, the fraud measure of damages. And this, in short, means that the claimant is entitled to recover all losses that flow as a matter of fact from the fraud, without, importantly, those losses being limited by considerations of reasonable foreseeability. So, for example, if you take a claimant who buys shares from a defendant in reliance on a lie told by the defendant as to the value of the shares, and without the defendant knowing, the claimant has funded that share purchase with a loan at an unusually high rate of interest. Applying the fraud measure of damages, obviously subject to the facts of the case, it would in principle be open to the claimant to seek recovery of not just the difference in value between the purchase price that he paid for the shares and the actual value of the shares, but also for interest payments under the loan, notwithstanding that those losses may not have been reasonably foreseeable at the time of the transaction. And there's a question, as I say, as to whether that fraud measure of damages applies in relation to claims under Section 90 and Section 90A, and that's an open question. Just dealing first with Section 90, on a first look it would be surprising if the fraud measure of damages was to apply here, because insofar as a claim under Section 90 has a fault element at all, the kind of fault standard is one of negligence, and that comes in via this defence of reasonable belief. So a defendant can say they reasonably believed that the statements were true, and that amounts to defence. So there's no fraud knowledge element in a Section 90 claim. But that notwithstanding, some commentators have suggested that the fraud measure of damages might apply to this non-fraud-based claim on the basis that the statutory wording in relation to compensation under Section 90 is similar to that in previous predecessor provisions under the Companies Act. And under those predecessor provisions, there is high authority, although from about 100 years ago, but high authority, that the applicable measure of damages should be the same as that applicable in cases of deceit. But the short and most likely answer to that point is that those cases which held that the fraud measure of damages should apply in relation to this non-fraud type of claim come from a time at which courts had not yet really developed the distinction between the fraud measure of damages and the measure of damages for negligence. And in addition, in relation to Section 90, it would have been open to Parliament to expressly import the fraud measure of damages, as they did in the Misrepresentation Act, but they didn't do so in relation to Section 90. So whilst this is definitely an open question, I'd suggest that the more likely answer is that the fraud measure of damages doesn't apply in relation to Section 90. Turning next to Section 90A, on its face, the case for the application of the fraud measure of damages here is stronger, or at least seems to be stronger, than in relation to Section 90, because the fault element in Section 90A is essentially one of fraud, and as Carl said, that's one of the key differences between the two causes of action. But that is not necessarily the end of the matter, because there are arguments that the scope of the damages recoverable under Section 90A should be narrower than in relation to the common law claim and deceit. So first, there's an argument that a claim under Section 90A is different in nature to a claim and deceit, and the liability judgment in autonomy that Carl mentioned records the submissions of the defendants to the effect that different policy considerations should apply in relation to a claim under Section 90A as compared with a claim in deceit, because of a number of reasons, but most importantly, first, the nature of the defendant, which is not the individual fraudster, but rather the corporate issuer. And with that corporate issuer is bound up the interests of innocent shareholders. And second, the nature of the documents in which the false statements appear, because under Section 90A, again, as Carl mentioned, the documents giving rise to liability are not selling documents, so they're not intended to benefit the issuer. So there's less of a punitive element, or perhaps should be less of a punitive element in Section 90A as compared with claims in deceit. The second reason why the fraud measure of damages might not apply is an argument that the terms of the statute, the terms of the statute in Section 90A circumscribe the scope of recoverable damages so that it's narrower than in relation to a common law claim and deceit. The statute provides that for liability in respect of loss suffered in respect of the securities as a result of untrue or misleading statements or omissions. And just breaking down that requirement, the loss must be suffered in respect of the securities. So that would seem to restrict claims under Section 90A to claims concerned with payments for or the value of the securities themselves. And in other words, it might be said to rule out claims for consequential loss. And just the second part of the statutory requirement, the loss must be suffered as a result of the untrue or misleading statement or omission. And on one view, this requirement would limit the recoverable damages to losses that are directly related to the statement or omission, rather than losses suffered as a result of acquiring the shares, but that do not bear any other relationship to these statements or omissions. So it's easy to see that issues as to recoverable damages under Section 90 and Section 90A could be big money questions, and in large part they turn on quite short issues of law as to the application or otherwise of the fraud measure of damages. Now, I said I wanted to address two issues of principle in relation to quantum in these types of claims, and the second issue is a much narrower, and you might be happy to hear a shorter one, and it's an interesting conundrum that applies in relation to claims under Section 90A, as I mentioned, brought on the basis that the claimant suffered loss as a result of continuing to hold shares in the issuer in reliance on the false or misleading statement. Now, in relation to these claims, a comparison of the actual and the counterfactual as at the date of the claimant's reliance on the published information gives rise to some interesting results, because in the actual scenario, i.e. what actually happened, the claimant has relied on the misleading published information and they've retained their shares at a value which is artificially inflated as a result of the non-disclosure by the company of wrongdoing. By contrast, in the counterfactual, in which the company did what it should have done and disclosed the wrongdoing, in that case, the shares held by the claimant would have diminished in value. So it seems as if the claimant is worse off in the case where there's no breach. Sorry, better off in the case where there's no breach. Now, one answer to this might be to say that even if the value of the shares in the counterfactual would have been diminished by the disclosure of wrongdoing by the company, the claimant might still have suffered loss in the factual if in the event they held on to the shares and then sold them for an even lower price at a later date. For example, if the market were to crash between the date of the published information and the date on which they eventually sold their shares. But even this might give rise to problems because, firstly, in this case, it would seem that the recoverable loss would be limited to the difference between the price at which the claimant would have sold the shares in the counterfactual following a disclosure of the wrongdoing and the price at which the claimant actually sold their shares, which may be a relatively limited quantum of loss. But there's also an issue of principle as to whether the issuer should be liable for those losses in circumstances where they don't arise from the misstatements or omissions in the published information on which the claim is based, but rather on something that happened after those statements or omissions were made. And if the claimant is to have any hope of recovering those losses, that's most likely to be by virtue of the fraud measure of damages, which again just illustrates perhaps the importance of that first issue which I mentioned. Just finally, very quickly, in the remaining minute or so available to me, I'd just like to touch on the assessment of quantum in practice. And I'm just going to address one short point under this heading in relation to trial structure. Intuitively, it makes sense to adopt a split trial in relation to quantum. And that is in large part because it makes sense to address quantum once the court has already made findings as to which, if any, statements in the published information were untrue or misleading, and which of those untrue or misleading statements were relied upon by the claimants. And that approach just allows the assessment of quantum to be targeted at these statements in relation to which the issuer is likely to be liable. But that said, in autonomy, the one Section 90A case which has reached trial to date, the court actually dismissed the claimant's application for a split trial and instead held a unitary trial lasting almost a year. But that may not prove to be a model for future case management, as in the event the court gave judgment on liability only and did not feel able to give a judgment on quantum. So, in short, the consequence of that has been the service of a further series of expert reports, then a satellite dispute as to the extent to which those expert reports should be admitted into the proceedings, and a further 5-day hearing, I think, at the end of this year for the purposes of interrogating the new expert evidence. So, to use the court's words, the lesson of this episode may be that quantum can, in a complex case, often only finally be decided after a judgment on liability. So it does seem as if a split trial may, in the end, be the way to go. So thank you for listening. I think that's all we've got time for on hot topics in securities litigation. But thank you.
Fantastic. Thank you very much, Carl and Jacob. Does anyone have any questions on securities litigation at this stage? No? Very good. Free to go. Thank you very much. So next up, we're going to talk about data and tech claims. We've got Victoria Wakefield and Zahra O'Keefe, who just need to get their microphones on. So just to explain, Victoria is going to consider data claims in the High Court, in particular the value of an opt-out mechanism and the limits of the compensation regime in the data protection legislation. And then Zahra will give a brief overview of some of the recent case law and touching on some overlap issues with competition law as well. So Victoria.
Thanks very much. Hi, everyone. In Lloyd and Google, Lord Legger expressly recognised that with the development of digital technologies, as he put it, that had brought with it the potential for mass harm for which legal redress may be sought. So that's obviously right, I would say. Such is the penetration of data and tech into all of our day-to-day lives that defendant wrongdoing can affect a huge volume of people. Each of those people may have suffered comparatively a relatively low value harm, but in aggregate, when you put all of that together, of course, the numbers can become very significant indeed. And so we see that litigation, which would have been unviable individually, becomes entirely possible when undertaken as a group. Keeping my claimant side hat firmly on for a moment, we also have defendants who tend to have very deep pockets. And we also have defendants who may see that they have a business model to protect, and so a disinclination to go to trial on difficult points. From a public policy perspective, we may see the value in private enforcement in parallel to public enforcement. Taking off my claimant side hat, popping on my defendant side hat, there's of course an abundance of interesting strategic and legal questions which are raised by these sorts of cases. Obviously, the defendant may be facing litigation in multiple jurisdictions, regulatory action coming from all over the world. And we know that all of those different regimes are different procedurally and in terms of their substantive law. We know that the EU, procedurally, is departing from us, or we're departing from the EU, because we know that the EU now is introducing collective redress mechanisms, representative action mechanisms, prioritising those ways of enforcing data rights. For the time being, no indication at all in this jurisdiction that we'll have that kind of bespoke regime. The defendant may be able to say the substantive law doesn't accommodate the kind of claim that's being brought against them. And finally, with the back against the wall, the defendant may find that they're fighting the case by reference to issues of principle that all of us may not, but may find truly fascinating. So really part of the bargain of everyday modern life, the quid pro quo that each of us accepts. Google would say, if you want to be able to Google for free, then Google's got to make its money somehow. That's through the adverts, that's through the data. So all of that is by way of scene setting, essentially, to convey to you, I hope, the message that collective redress in the field of data and the tech sectors is a very exciting field, it's a very fast-moving field. New law is being made all the time, substantive law, procedural law, new developments happening all the time. So I'm very mindful, of course, as Tony said earlier, this is a commercial conference, so I won't hold forth about the competition regime. I think Sarah will say a little about it when we come to her talk. But of course, we see, just by way of example, in the competition regime, these points are being put as abuse of dominance. So that's an example of the sort of creativity that's being deployed. So I'm going to focus on claims in the High Court, and I'm going to focus in particular on representative proceedings. I'm going to start by saying something quick about the value of opt-out compared to opt-in. Then I'll deliver the relatively bad news from a claimant's perspective in relation to the bespoke data protection regime. And then finally, I'll focus on future creative ways of bringing those claims still. Much of what I say will naturally be formulated from a claimant side perspective because I'm thinking, what next? But for those of you with defendant hats on, obviously just think the opposite. We'd run a point one way, run the answer the other way. So opt-out versus opt-in, you know what I mean by opt-out, but it's so important that we recognise the value of that kind of procedure. It's a procedure where we have no contact with the class members. So on the claimant side, you define your class. All members in the class are part of the proceedings. Their causes of action are being litigated. It will be res judicata subsequently, and you have no contact with them until after judgment. Now, that is to be contrasted with a GLO or a conventional multi-party claim, in which one necessarily needs a degree of contact with each claimant. They need to opt in, they need to enter into the funding agreements, one needs to obtain evidence from them, or at least some kind of tick box about which bucket they fall into. And the big value of opt-out compared to opt-in is, of course, the numbers are much bigger in an opt-out claim. It is very hard to get affected individuals to engage with mass litigation. That's just a reality of running those sorts of claims. So if we think about the Morrisons GLO, their big data breach from however many years ago, the one that went to the Supreme Court. 100,000 employees were affected. Very easy for them to sign up, tick a box in the staff room, in the canteen, wherever. 5,000 of the 100,000 signed up. And that's about right in terms of take-up rates at the beginning of litigation. A bit better at the back end when you're distributing damages, but take-up rates are low. So opt-out is extremely valuable from the claimant perspective, also extremely valuable from the public policy perspective of truly vindicating the rights or truly punishing the harm that was caused by the breach. So thinking about representative actions, Gerard and Jaamae are going to talk about that in more detail later this afternoon, but the core concept is same interest. So if you're trying to bring representative actions, they're opt-out, inherently opt-out, but you're thinking about how can I show same interest without any contact at all with my class. Okay, so it has to be entirely non-individualized. I don't need any proof. They don't need to tell me anything. The holy grail of the claimant side endeavour is to identify a way of putting the claim which doesn't require any claimant side engagement at all, but we show same interest, so no individualised proof at all. Turning then to the bespoke data regime, the bad news from the claimant side is that the statutory entitlement to damages under both the old DPA regime and, in my view at least, under the new UK GDPR, does not include an obvious non-individualised type of damages. So we know that from Lloyd and Google, and we know it from recent Court of Justice authority. Starting with Lloyd and Google, in which I acted for Richard Lloyd, and shout out to everyone here who was there as well. We sued under Section 13 of the old Act, and that says, sorry to read law out, I know it's a bit boring, but this is just one sentence. An individual who suffers damage by reason of any contravention by a data controller of any of the requirements of this Act is entitled to compensation from the data controller for that damage. So we sued for what we called loss of control damages. I'll come back to that later. But we say that's the harm caused to data subjects when they lose the valuable ability to control their data. And we say that that is accessible in the abstract, essentially. You don't need to ask each person, did you value that right? Because the right's given by the legislation. It's there, it has a value attached to it. The other side said that that collapses the statutory definition on itself, because we take infringement and we say infringement constitutes damage. But those words from Section 13 say the infringement has to have caused damage, so they had to be separate things. We framed our claim on what we called a lowest common denominator basis. So we sued for the core, irreducible minimum set of facts that were the same for everyone, another reason why we didn't have to have any contact with the class. So the Supreme Court was prepared, without deciding the point, to proceed on the basis that lowest common denominator is a way of fulfilling same interest. That in itself is a massive win in terms of framing the claim, because everyone can have different amounts of harm that they've suffered, different amounts of use of the internet, and you can chop off all of the top bit and sue only for the common minimum. And the Supreme Court said, it didn't love the idea, but it said if that's essentially the only show in town, you have to be pragmatic. That's the only way of bringing these claims. Without deciding the point, Lord Leggett was happy to go forward on the basis that that was acceptable. However, he said that the other side, Google, were right about Section 13. And what we'd done impermissibly was collapse infringement, breach of the data rules with an entitlement to compensation. Instead, there had to be some kind of material damage or some kind of distress. So, loss of control damages off the table. They also said user damages, which we'd sue for in the alternative, off the table. I'll come back to that in a little bit. Subsequent to Lloyd and Google, the question has arisen whether the position might be different under the GDPR. It's a new regime, after all. Article 82, sorry, I'm going to read another sentence out, provides any person who has suffered material or non-material damage as a result of an infringement of this regulation shall have the right to receive compensation from the controller or processor for the damage suffered. So you'll immediately see it's the same sort of structure. Right, we have a breach, we have causation, we have damage. So it seems pretty obvious to me that Lord Leggett's reading, the Supreme Court's reading of the old regime, Section 13, is likely to be the same for Article 82. And it's likely to be the case that one can't simply point to the infringement and say that in itself is harmful. My view has been confirmed by a recent judgment of the Court of Justice, the Austrian Post case, that's case C300/21, judgment handed down on the 4th of May of this year. And they said that the existence of an infringement by itself does not give right to any entitlement to compensation. Again, flowing from the literal wording of the provision. So since Lloyd and Google, since that judgment of the ECJ presaged by an AG's opinion in a different case, I think I'm right in saying that all of the cases that have been built in the model of Lloyd and Google have withered away. TikTok, which I think passed strikeout or service out, I think was then discontinued. I don't think there are any that remain. So looking forward to the future, that all sounds terribly gloomy and like there's nothing that we can do collectively on an opt-out basis for data rights. But even just focusing on the GDPR, I don't think we need to be as gloomy as all that, because we do, after all, have an entitlement for compensation for material or non-material harm. The problem is, how do we get that to the same interest position? So there could, of course, be the dream case, the dream set of facts, where it just is the position that everyone has suffered an obvious, irreducible minimum financial harm or possibly distress. But I think one can be even more creative, perhaps. So it may be possible to circumscribe the class, for example, having conducted a proper, robust, statistically valid survey of the types of loss caused by a known data breach. How many people suffered financial harm? How many people suffered distress? Let's not forget that the mechanism of a representative action is that you litigate one claim and it binds all other claims which are the same as it. And so one could say, well, the data breach affected 1 million people, 100,000 of them suffered financial harm because the credit card details were then used to make a purchase. And so I'm suing for the 100,000 identical claims. That's my class. That seems legitimate to me. And then at the back end, when we get to distribution of damages, it's a lot easier to get the necessary proof off the person. And often, even in opt-out in the competition regime, one might ask for proof at the back end of it. So I think it really isn't the total end of the road, I have to say, for opt-out collectives using the proper data protection regime. But I also think there's quite a lot to be said about the tort of misuse of private information. And I'll take this relatively quickly. I'm sure I've spoken for too long. I often do, sorry. But the tort of misuse of private information really came out of Lloyd and Google as the blue-eyed boy. It came out of that judgment very, very well. We know that the tort of misuse of private information, for those of you who don't know its history, so it came out of the equitable action of breach of confidence. It's influenced by Article 8 of the ECHR. You need to show reasonable expectation of privacy. You need to show an intrusion. The claimant doesn't need to know that it's happened, so this is a tort that children can often rely on. There doesn't need to have actually been misuse or publication. So it's a bit of a funnily shaped tort, but a very useful one in the modern age. We know that both of the types of damages we were seeking in Lloyd and Google are definitely available for MPI claims. We could have guessed that anyway. We knew it from the Court of Appeal for loss of control damages because Gulati told us that. That's the phone hacking case. Lots of the phone hacking, they listened to the messages, didn't do anything further. It was a really boring message. But we know the Court of Appeal said mere infringement of the right gave right to essentially a tariff award of £10,000. So that's super useful for MPI claims. We also know that we've got user damages available. Now, I've always really liked user damages in the context of data. I like them anyway, but I like them in the context of data because, don't forget, user damages, it's what we used to call root and park, what's now one step. And it's the idea of taking someone's property, someone's asset, and using it without paying the relevant license fee, hypothetical license fee, hypothetical release fee. And of course, core to the notion of user damages is you don't need to have hurt the thing that you took or you copied. So if you think about Lord Shaw's speech in Watson Laidlaw, I'm sure it's at the very top of your mind, but when he gives that example in his speech of a very posh person in the olden days who had lots of horses, and somebody took a horse without asking and rode it around and brought it back. And Lord Shaw said, well, it was all the better for the exercise. All the better for the exercise, but you still get compensation for it. And for me, that strikes home when I think about a lot of the use of data. Difficult to say that it really hurts you. You know, you Google for free, they use a bit of your data, maybe you get a slightly more useful advert, it's not that bad. But we see that it really fits in with all of that case law of Victorian origin. And we know that that's available for MPI claims. Now, the obvious MPI claim at the moment is Prismal, and that's something that Gerard's going to talk about. I'm not going to trespass onto his territory. It failed at first instance. It's going up on appeal, but it failed on reasonable expectation of privacy. And Heather Williams accepted that as a necessary concomitant, if there were to be common reasonable expectation of privacy, there would be common entitlement to damages, essentially. So the same interest element of it would have worked. And my view, what do I know, I'm not in the case, but my view is that may well succeed on appeal because that's healthcare data, and that's the sort of data one would think there would be a reasonable expectation of privacy in. So that's all very exciting. I'm sure I've spoken for far too long, but I just wrap that up by saying that I think this is a very interesting field. It's a field with massive strategic creativity, procedural creativity, legal creativity, and I think whether one's claimant side, defendant side, or both, it's just a great field to work in. So I commend it to you, and I hope that's been of some interest. Thank you.
Thank you, Victoria, for that discussion, which I think in particular highlights the need for creative thinking in the group litigation sphere when it comes to data and tech claims in particular. And I'm going to continue with that theme. I think, as I see it, the need for creativity here really comes from two key features of data and tech claims. The first, as Victoria's explained, particularly in the context of Lloyd and Google, is that often when it comes to data claims, the value of those data rights is either low or uncertain. And the second key feature is that also we're still trying to figure out where these data and privacy harms really fit into the legal structures that we already have. So there's that second uncertainty of the best way to plead a claim in a given case. So I'm going to explain how these features give rise to some creative thinking in three particular areas. First of all, in terms of some case management options that are available for this kind of group litigation. Second, about choosing a cause of action, so building on what Victoria's already spoken about. And then finally, the possible impact of a few pieces of new legislation that are coming through at the moment. So first, creative case management. So we've already heard about the main opt-out option, which is the representative action in Lloyd and Google. In the opt-in sphere, the main tool is the GLO, the group litigation order. Now, Simon and Joe are going to be speaking about that in a bit more detail later on this afternoon. But the point for data claims to note about GLOs is that they have very, very large upfront costs, right? To administer the GLO, you need to put together a register, you need to spend money on advertising. Now, there are GLOs that are made in respect of data claims. So, for example, the BA group data breach litigation. But they aren't always the most proportionate option when it comes to this kind of claim, particularly where large numbers of claimants are bringing very low or very uncertain value data breach claims. So another option that is at the court's disposal is to use its general powers of case management to treat the claims as a managed multi-party set of proceedings. Here's some test cases first, and then stay the rest of the claims. The main drawback of that is that, unlike the GLO, any decisions made in those test cases are not binding, they're just influential. However, a lot of the time in these data breach type cases, it can be the more appropriate option. So, for example, in Equifax, the court decided to appoint a case management judge when there was a GLO application made, and to defer consideration of the GLO application to that judge at a later stage. And it decided to do that because it saw force in the defendant's arguments that claims might be more proportionally dealt with by hearing issues about quantum and causation brought by these sort of data breach claimants first as a preliminary issue and only in respect of a sample of test claimants. And the judge essentially thought that could be more proportionate to do before any money was spent on advertising, on putting together a register, etc. And then later on in Beck, where a hack allegedly compromised the personal data of 13,000 members of the Police Federation, The claimants had originally sought a GLO, but then decided to agree with the defendants that actually the more proportionate solution would be to proceed by way of test cases as part of a sort of case-managed ordinary claim. And there was then a costs application. And in that costs application, the claimants were ordered to pay 50% of the defendant's costs on the basis that even though the threshold for a GLO had been met, the claimants were under an obligation to consider at an earlier stage these alternative proposals that had been made by the defendants, which the court considered were more proportionate. And in particular, that was because Practice Direction 19B puts an obligation on any applicants for a GLO to consider first whether any other order might be more appropriate. So I think the point of that is that where you are confined to an opt-in situation, it's important to always consider, rather than just assuming that a GLO is going to be the most appropriate solution, it is worth considering whether there are other case management options available that might be more proportionate. And that's particularly important in data claims, where we are often talking about large numbers of claimants for little value. But moving then from procedure to substance, there's even more scope for creativity, because often the same underlying data infringement can give rise to multiple different causes of action. Depending on the circumstances, a DPA or UK GDPR claim might give rise to the type of MPI claim that Victoria was talking about, but it could also give rise to some sort of breach of confidence claim, a consumer protection claim, something in negligence, or even something under Article 8. So in that context, if we take, for example, the TalkTalk group litigation, in addition to their ordinary sort of DPA standard compensation claim, the claimants had also pleaded a claim that was building on MPI and was saying that in that situation, the defendants had enabled or facilitated hackers to misuse the private information of the claimant's data that was accessed. Now, the court decided to strike out that additional MPI claim, and there is a bit of a trend in some of these cases, both collective and individual, to strike out those sort of additional claims that don't necessarily add more compensation to what's on the table beyond the core data claim. But there is that scope for creativity there, and in particular, one of the ways that it's useful to be creative and that can add a different aspect is if you're able to frame your claim as a competition claim. Now, as we've said, this is not a competition litigation conference, but it's very difficult to talk about these kinds of data breaches without making reference to the competition regime. Because A, when we're talking about valuable aggregated data, often the only companies who are able to leverage that really effectively are ones who are dominant in markets. So it covers a lot of the same ground. And B, it's important to understand the limits to that overlap, so where there might be a need to fall on one side of the boundary as opposed to the other. So if you can frame your group claim as a competition law one, the benefit is obviously that the Competition Act establishes under Section 47B this collective opt-out regime, and that has all of the benefits in terms of financial viability of the claim, because you don't have this big upfront expenditure and you don't have these problems with uptake that both Kyle and Victoria mentioned earlier. But the difficulty is that the Competition Appeal Tribunal's jurisdiction is limited just to competition issues. So the types of claim that you can bring are restricted in scope. And the Gormson and Meta case is quite instructive in this regard. So just as background, the way the competition regime works is that you have a proposed class representative, or a PCR, who applies for certification of a claim to be brought on behalf of a defined class. And what they have to do at that certification hearing, broadly speaking, is to establish that they have a sufficiently viable methodology to establish loss on behalf of the class on a class-wide aggregate basis. Now, in Gormson, the PCR had pleaded 3 different ways that it said Meta had abused its dominant position, all related to data. And the CAT was prepared to treat the first 2 as falling within the scope of competition law, And those two pleadings were essentially that Facebook's terms, which required access to user data for advertising purposes, A, amounted to an unfair data requirement, which was imposed as a precondition by this dominant company to access the Facebook network, and B, amounted to an unfair price, so essentially users were paying too much by giving up their valuable data assets. The third way, however, that the PCR tried to put its claim was not sort of seen as falling within the scope of competition. So essentially, what they had said was that Meta had imposed other unfair trading conditions on users, and this included pleas that the terms and conditions were too complex, they were too long, they changed too frequently, they didn't provide adequate explanation about how the data was collected and used, and also that changes in the policy degraded the protection of privacy over time. Now, the CAT described that as extremely difficult to pigeonhole as an abuse of dominance claim and suggested instead that it looked more like a consumer protection action, which was beyond the CAT's competition jurisdiction. In the end, the CAT held that the PCR hadn't established a sufficiently viable methodology in respect of any of its claims, and it gave it essentially 6 months to come back and try again. But the key point for these purposes is that that case really shows just how blurry the lines can be between the causes of action that apply, particularly when we're talking about these kinds of data claims, these kinds of tech claims. To add yet further complexity, there are two new pieces of legislation that seem pretty set to change the landscape in data and tech going forwards. So in Europe, we've got the Digital Markets Act, or DMA, which recently came into force, while the UK equivalent, the Digital Markets Competition and Consumers Bill, or DMCC, is going through Parliament at the moment. Without getting into too much detail, in very broad terms, both these acts designate certain big tech companies as having to comply with a range of additional obligations and requirements that relate to digital markets. And I think for this talk, there are 2 points that are worth noting. The first is that both regimes contain quite an interesting mix of what are traditionally seen as competition law obligations. So, for example, various rules about interoperability and self-preferencing, but also they introduce a bunch of other rights. So some of them seem pretty specific to data protection because they prohibit certain forms of processing. Others look like consumer protection legislation because they try to sort of regulate design and choice architecture in terms of how choices are presented to customers and consumers. But the second key thing to note is that in terms of collective redress under the regimes, Article 42 of the DMA expressly requires member states to make representative actions available to enforce DMA rights, sort of in keeping with the theme that Victoria was talking about earlier. Whereas the DMCC is completely silent on the point. Now, unless things have moved on, because this has been something that's been being debated, as far as I understand, the current form of the DMCC does not propose to sort of introduce an equivalent to the competition collective action regime, even though there are a lot of calls for it to do so. And if that stays the way it is, that could leave claimants in quite a difficult situation, because if they're faced with something that is clearly a breach of a DMA requirement, so they've got a solid case if they were to take it forward as a GLO, but they could alternatively reframe it as maybe a slightly more speculative competition law action, would it be worth benefiting from the sort of opt-out nature of that in order to pursue the competition claim, or is it better to stick with the slightly sounder GLO? We'll see how all of that progresses, but I think it looks like things are only going to get more complicated in terms of how we creatively frame these various tech claims going forward.
Excellent. Thank you very much. Victoria and Sarah, can anyone ask a question at this point, or are we straight on to the next talk? Fantastic. Thank you very much.
You've answered everything already. Great.
So now on to ESG litigation, Tim and Jessie. So just while Tim and Jessie are getting their microphones ready, Tim is going to give an introduction to ESG litigation, so touching on the current legal framework, including the new European directive, also mass tort claims by direct victims, for example, the Vedanta case, and also give us a bit of an angle on the public law regulatory position. And then Jessie will touch on shareholder claims against directors. Obviously, we know about the Client Earth case recently. Also claims against directors of pension funds and greenwashing as well. So over to you, Tim, when you're ready.
Thanks, Tony. I should start with an apology. You were supposed to be hearing from Richard Lord, King's Counsel at this point, but unfortunately he was professionally double booked. So I've been slotted into what's called the graveyard slot. This is the window where you're furthest from lunch, closest to tea, but I can promise you tea is only 25 minutes away. There may even be biscuits, and I hope it's going to be stimulating. I am a member of Birt Court. I specialise in public international law, public law, competition law. So I'm something of an interloper in this commercial conference, but what I want to do is talk about ESG litigation, so environmental, social and governance litigation. Now, I think it's fair to say that ESG is not a field of litigation as we would conventionally understand it. Really, at the minute, I think it's largely an internal function within our clients. So they have their HR function, they have their finance function, and they'll also have increasingly an ESG function, and that's a part of the business that will be very cross-cutting. It will touch on supply chains, packaging, carbon emissions, modern slavery, and so on and so forth. And what I'm going to be talking about with Jessie is some of the litigation that we're beginning to see coming out of the ESG space. We're going to have a very quick scan over some of the trends and how we might assist or advise our clients. So, what's the legislative regime in relation to ESG? I think you can probably summarize it this way. There's a lot of it. It's rather fragmented, and it's not terribly coherent. It's dotted out in different places. So, just going through it very quickly to give us some context. Firstly, as you probably know, directors will have duties under the Companies Act. Jessie's going to talk about some of the claims that have arisen out of those, but Section 172 will oblige the directors to have regards to the interests of their employees, the impact of the company's operations on the community and on the environment. And then Section 414A to C imposes, at least in regards to large companies, a duty to publish a report, a strategic report every year that looks at the business's impact on the environment, various human rights issues, and so on and so forth. And if they're listed on the stock exchange, of course, they'll have probably additional annual reporting obligations there. The second aspect of the sort of legislative or quasi-legislative framework is the Task Force on Climate-Related Financial Disclosures. This is a relatively new thing, and it requires companies, again, over a certain size, to make disclosures in relation to governance, relating to climate risks and opportunities. How are they measuring those risks? How are they mitigating those risks? What's their strategic climate plan? And there's actually more obligations in that space on the way. Thirdly, the Modern Slavery Act. There's a fresh bill before Parliament to update that, but the 2015 Act really focused on the supply chain. And again, businesses, or at least some businesses above a certain size, have to publish an annual statement setting out how they've taken steps to ensure that there isn't slavery within the supply chain. There's also the UK Corporate Governance Code. I told you it was fragmented. The UK Corporate Governance Code, which has various other obligations that have to be complied with as well. And then at the European level, obviously the new European Corporate Sustainability Reporting Directive, upping the level of analysis that our clients have to do, the level of disclosure they have to provide, the kinds of documents they have to produce. There's more that we could talk about. We could talk about the UN Guiding Principles. Lots of our clients will have signed up to them and effectively, to some extent, committed themselves to apply them, as well as the OECD guidelines for multinational enterprises. So we have an absolute plethora of these obligations from lots of different sources, and it may well be that you get asked by your clients to help them to prepare them at a certain point in the year. Now, the question for today that we really want to focus on is how those obligations can either give rise to or can be relied upon in the context of litigation. And the answer is yes, they can, they are being, and what we've already seen in the litigation space, at least my suggestion is that's just the tip of the iceberg of what we're going to see. So 3 examples of that. Firstly, mass tort claims. So the best known example of this, obviously, is Vedanta and Langowi. That was a case I was instructed to intervene in the Supreme Court for the International Coalition of Jurists. You're probably familiar with the background. A large tort claim, 1,500, more in fact, Zambian citizens who lived near to the Konkola copper mine. The claim was for personal injury and for property damage because water had leaked, toxic discharges had leaked from the mine into the watercourse. Now, Vedanta, the UK company, was the parent company of the copper mine in Zambia. And the claimants sued Vedanta here. And the case, or the nub of the case, concerned whether or not the claimants had an arguable claim against Vedanta. And Vedanta's argument was pretty familiar. They said, look, we're a parent company. We don't know what's been going on at this mine. That's not our responsibility. That's why we have separate corporate legal personality. And this is going to be a very novel, controversial extension of tort law if you say that we might, at least in principle, for the purposes of serving out, say that we are a proper defendant to this. And the Supreme Court was having none of it at all. And what they did, the reason the Supreme Court found against Vedanta, is they went to their ESG documents. So they went to the documents Vedanta had produced explaining how they, for example, guarantee environmental standards on the part of their subsidiaries around the world. And effectively what the Supreme Court said is, you've been telling your investors, you've been telling people who you are obtaining capital from, that this is the kind of business that they're investing in. And so you've said, we will take responsibility for the conduct of our subsidiaries. We will comply with these standards. And as a consequence, you are, the way the case law works, or the way it's articulated, is you've assumed responsibility for the purposes of the tort of negligence for the actions of those subsidiaries. But as I say, the nub, the heart of the argument, was digging out all of these seemingly tedious ESG reports and going through them and saying, well, what have you been telling the world you are doing? Second example, Okpabi and Shell, very similar legal analysis, very similar context overseas, environmental damage by one of Shell's subsidiaries. And again, the global oil spill policy is right at the center of the Supreme Court's reasoning. They're looking at how it is that these companies are articulating what they do through these documents to the world. Now, these are obviously mass tort claims. They're not class actions in the ordinary sense. But what we're seeing is a willingness on the part of the courts to cut through some of the traditional arguments about corporate structure. And the willingness to do that is tied very closely to the ways in which companies are now having to present themselves and are choosing to present themselves and present their relationships within their corporate groups. Now so I talk about this quite a lot to companies. And one of the conversations that always arises is, well, it isn't the appropriate strategy then to effectively say we take no responsibility for our subsidiaries and we have no idea what they do, the sort of corporate deadbeat dad strategy. To which my answer is always, I don't think that's going to work, actually. For a start, I don't think it's going to work because I think you may well find yourself in trouble with various regulators, and I'll talk about that in a moment. But also, your investors aren't going to want to invest in a company like that. Your shareholders aren't going to want to invest in a company like that. I think the day will come when somebody runs the kind of legal deadbeat parent argument in the Supreme Court, and it'll be fascinating to see what the Supreme Court does with it. But that's always, I mean, that's the conversation I've had time and again with companies that I'm advising in this space. To my mind, I think that is a strategy that simply isn't going to work in the investment and in the environment context that we're in now. So I promise to be quicker on my second and third category of claims, but that's mass tort claims. Secondly, we've just seen the first claim under the Competition Appeal Tribunal's opt-out class action jurisdiction that's squarely in the environmental space. So that's Roberts and Severn Trent Water. And actually, they're going to subsequently sue all of the water companies, as I understand it. And the nub of the claim is they're saying, we're seeking damages based on your failure, the water companies, to comply with your reporting obligations and to comply with environmental law. And the basic allegation is you've abused your dominant position to underreport sewage incidents. And had you reported them, then Ofwat would have said, okay, we're now going to cut the fees that you can charge to your customers because you've discharged too much sewage into the waterways. It's going to be fascinating to see how that case proceeds, but it's the first straw in the wind, I think, of how environmental claims of this kind are going to find their way into the CAT opt-out regime. And then finally, the third sort of category of actions, I'll skip through it quickly because it's not squarely in the kind of group litigation space, but I think we are going to see more direct enforcement from government agencies in relation to environmental compliance. And we're seeing this already. The Environment Agency last year issued the first ever fines to 30 different companies who'd underreported their carbon emissions or failed to submit their reports on time. And the fines were of the order of £1 million or £1.5 million. So they're not enormous fines by reference to the companies in question, but you're starting to see the beefing up of that willingness on the part of regulators. As you know, the ASA have been clamping down on greenwashing. Watch this space. The FCA have just appointed a director for ESG to ensure that companies are complying with their reporting obligations. So there are going to, or I think there's going to be increasingly, not just claims on the part of claimants, but we're going to see regulator versus company disputes emerging out of this space. I'm going to stop because of time and hand over to Jessie, but thank you for listening.
Thanks, Tim. As Tim mentioned, there's been a number of high-profile climate change cases recently. Globally, the number of climate change cases more than doubled to over 2,000 between 2015 and 2022, with about 25% of these filed in the past 2 years, and that's according to the London School of Economics Environment Institute. And a growing number of these cases involve shareholders and members bringing group litigation against their own companies for ESG failings. I'd like to touch on 3 areas. First of all, shareholder claims against directors under the Companies Act. Second, member claims against directors of pension trustees. And third, investor claims for misrepresentation and greenwashing. Each of these areas has contributed to the massive increase in ESG litigation over the past couple of years, though it remains to be seen whether large group actions by members and shareholders are a suitable vehicle by which to bring ESG litigation. So turning to the first category of claims, this is shareholder claims against company directors under the Companies Act. So as Tony mentioned, perhaps one of the most high-profile cases recently has been Client Earth and Shell. The environmental NGO Client Earth, which had a token shareholding in Shell for this very purpose, brought a derivative claim on Shell's behalf against Shell's directors regarding the company's climate change risk strategy. The claimant alleged breaches of Section 172 of the Companies Act, which is the duty to promote the success of the company, and Section 174 of the Companies Act, which is the duty to act with reasonable care, skill, and diligence. And under Section 172, one of the factors a director must have regard to in exercising the duty to promote the success of the company is the impact of the company's operations on the community and the environment. So at first blush, it would appear that a claim under Section 172 is ripe for climate change litigation. The claimants in Client Earth specifically alleged that the directors had failed to set an appropriate emissions target and that they had failed to ensure that Shell had a measurable and realistic pathway to achieve net zero by 2050. Now, under Section 261 of the Companies Act, a member who brings a derivative claim must first obtain permission of the court in order to continue with the claim. The court must agree that there is a prima facie case and then give the shareholder permission to continue. Now, in this case, Mr. Justice Trower disagreed that there was a prima facie case to bring a derivative action. The judge found that there was no basis, there wasn't a prima facie case, that there was no basis on which the directors could reasonably have concluded that the actions they had taken had not been in the interest of the company. There was no agreed methodology on how to set a measurable and realistic pathway to meeting the net zero target against which the directors' action or inaction could be measured. So the court held that the claimant's case ignored the fact that the management of a business of the size and complexity of Shell would require the directors to take into account a range of competing considerations, the proper balancing of which were a classic management decision, in the words of the court, with which the court was ill-equipped to intervene. So we can see from Client Earth that there's a very high bar to establish a breach of directors' duties for climate change related decisions. While under Section 172, a director must have regard to the impact on the environment, in his duty to promote the success of the company, that's all that's required. The director can decide, whilst having regard to the impact on the environment, that in this particular commercial decision, it is in the interest of the company not to have that much regard to the environment, in fact. And so, unless and until there is a universally accepted methodology by which climate change action can be measured, it will be difficult to prove that directors have not acted reasonably in addressing climate considerations. The weight to be attached to competing considerations in a commercial decision with which the court is ill-equipped to intervene means that the court is unlikely to allow such derivative claims to proceed unless there's such a clear case. So turning to the second issue, in a similar vein of litigation was action by members of a pension scheme against directors of the pension trustee company. So recently, there was the Court of Appeal case of McGaughey and University's superannuation scheme. This again was a derivative claim against the directors of the pension trustee company for a breach of Section 171 of the Companies Act, which is exercising powers for the purpose for which they are granted, and Section 172, which is again the duty to promote the success of the company. The members of the pension scheme alleged that these sections were breached by a continued investment in fossil fuels and a failure to have an adequate plan for divestment. The judge at first instance found that the fossil fuel claim was not a proper derivative claim, as there was no prima facie loss to the company itself, and the Court of Appeal agreed. There was no prima facie case that the pension scheme had suffered a loss as a result of the alleged breach of directors' duties, and the claimants themselves couldn't establish that they too had suffered a loss because of the continued investment in fossil fuels. The Court of Appeal said in quite strong words that the fossil fuels claim is an attempt to challenge the management and investment decisions of the pension trustee company as trustee without any ground upon which to do so. And the court in Klein Earth similarly criticised the claimant for this, stating that the primary purpose of bringing the claim was an ulterior motive in the form of advancing Klein Earth's own policy agenda, and the court had discretion to refuse permission to proceed on this basis. So from these two cases, we can see that the use of derivative claims is a difficult vehicle for shareholders and members to bring ESG litigation. There's the additional hurdle of needing to establish a prima facie case to obtain the court's permission to proceed with the claim. And there's now the precedent of Klein Earth and McGaughey criticising the use of derivative claims for ESG litigation and emphasising the court's discretion to dismiss a derivative claim on the basis that the claim isn't brought in good faith as a true derivative claim for harm to the company itself. This isn't to say that the door is completely closed for shareholders to bring derivative claims in ESG litigation. Where there's a clear failure of directors to address a climate-related target, for example, for which there is an accepted methodology for achievement, and that failure has caused a loss to the company, then derivative actions by shareholders may in fact be suitable. So now turning to another ground on which group actions can be brought against companies, I'll now say a few words on investor claims for misrepresentation and for greenwashing. This is another growing area of ESG litigation. You've heard earlier from Kyle about the framework for investors to bring claims under Sections 90 and 90A of the Financial Services and Markets Act for untrue or misleading statements in a prospectus or other published document. And there is a potential for Section 90 and 90A FUSMA claims to be used as a vehicle for ESG litigation for misleading statements about a company's environmental credentials, which is colloquially known as greenwashing. An example of this is where FIFA mentioned that the Qatar World Cup was carbon neutral, but then had no way and no evidence of proving that all of the emissions generated by the World Cup could be offset. So while there don't appear to be any Section 90 or 90A claims in the ESG field as yet, there have been claims brought for claims relating to the environment and for greenwashing yet. There have been claims in the wider ESG field. Earlier this year, 197 funds sued Glencore for untrue statements in their prospectus relating to bribery risk. And the difficulty, however, as we've heard, is that Section 90 and 90A FUSMA claims, and the difficulty in making these out, is establishing reliance. Investors will have to show that the specific impugned statement about the environmental credentials of the company was a statement that induced them to buy the security. It's likely that this aspect of reliance will be the main hurdle that investors will have to surpass in bringing Section 90 and Section 90A claims. And the same difficulty would be faced by investors bringing traditional misrepresentation or misstatement claims as well. So if we look to the future, I think there's a hurdle in adapting ESG litigation into typical class actions brought against companies, such as derivative actions and Section 90 and 90A FUSMA claims. There is a high bar, particularly in relation to establishing reliance and loss for group shareholder actions to succeed in derivative claims in ESG litigation. However, there's still much enthusiasm within this space for these sorts of cases. And as Tim mentioned, this is just the tip of the iceberg. And I expect that we'll be seeing many more ESG cases in the years to come.
Excellent. Thank you very much, Tim and Jessie. I'm going to assume no one has a question unless someone wants to ask anything about ESG litigation. Yes, thank you very much at the back.
Thank you very much. Jonathan Webb here from ZFZ. Tim, to you, just a point of clarification. You said in the context of the Zambian copper case, that was a mass tort claim rather than a class action per se. Could you just explain to the uninitiated what the difference is?
So in very, very crude terms, mass tort claim is a claim where a large number of people all sign the claim form. They may have suffered different kinds of loss quantified in different ways, and they all have to make out their loss. Whereas class action claims, or at least some kinds of class action claims, will be a claim where everyone says, we've all suffered the same loss. And so there is... Exactly. But there isn't a distinct... It's not to do with how many people are involved, but it's simply the nature of the kind of claim that's being brought, or the premise of the claim. So for example, a data claim might be circumstances where you're saying we've all suffered the same loss, all following from the same breach of our right to privacy, or whatever it might be, or misuse of our data. And so that would be more traditionally understood as a class action. There's also within the Competition Appeal Tribunal a bespoke regime for class actions as well, which is particular to the CAT and to competition law, but that's a whole other conversation.
Thank you very much. We're going to pause there for 20 minutes or so, so help yourself to some tea and biscuits downstairs, and then see you back for the second half.